this guy's garage. Like and subscribe.
As provided by the DPP Act, the DPP needs to be able to provide clear guidelines to prosecutors regarding their exercise of discretion and allow the Attorney General to be notified of prosecutions that raise issues of general interest in sufficient time for him or her to react if they choose. The exception to this, of course, is with respect to the Canada Elections Act.
Congratulations, sir, on your nomination and for your appearance before the committee today. I was pleased to be part of a government that created the public prosecution service and the role of director. And it's been interesting to watch the evolution of that organization. I only have 6 minutes, so I'm going to try and ask my questions kind of tightly and hopefully get a tight response. But the role of the public prosecution service in prosecutions under the Controlled Drugs and Substances Act. My understanding is the service is responsible for prosecutions under the Act in all provinces, territories except Quebec and in New Brunswick when the RCMP is the police jurisdiction. Is that correct?
That's correct. In Quebec, we also prosecute when the RCMP is, in their federal capacity, are the police force. But otherwise, all other police forces, theirs are prosecuted by the province.
Okay. So in August 2020, the Director of Public Prosecutions issued a directive to prosecutors when dealing with possession cases of the Controlled Drugs and Substances Act, which essentially was not to prosecute possession cases unless it was the most serious case and cases involved a public safety concern. What impact, if any, would that directive have had on those jurisdictions? Were we behind those other jurisdictions of Quebec and New Brunswick, or would they have followed suit from that directive?
Each of those jurisdictions has their own policies and guidance with respect to that, and they determine what is appropriate for themselves. Ours was one that was crafted specifically with consultations, among others, with the provincial prosecution services, but also Health Canada, the police, the Canadian Chief of Police were directly consulted and supportive, as were other care professionals involved. But I know that Quebec and New Brunswick have slightly different policies.
Okay. I mean, as you know, we're dealing with an opioid crisis right now. Deaths, overdoses have skyrocketed. Organized crime is involved at every level, of course. And there's been legislation that has allowed, for example, where there used to be mandatory jail time for production, importing, exporting of Schedule I drugs, for example. Under Bill C-5, there's no longer a mandatory sentence for those charges. On the issue of possession, can you illustrate maybe if there is such a thing as a typical case where a charge would be brought now that we're a few years post that directive? What type of drug particularly, and then what type of scenario, if you could give one, where you would expect that a charge would be brought?
Absolutely. The guideline is very specific to our prosecutors, and although some people have interpreted it as a don't prosecute unless, it's very clear that it places directly the public safety question first and foremost, but recognizes that there's an enormous health component to this question. The sorts of scenarios that it contemplates specifically and that I can give as examples would be ones, for example, where youth are targeted or used as part of the possession, where persons who are in positions of trust, for example, persons who might be in an institution like a prison, are involved, where firearms are involved, or small communities specifically recognizes that it's not a one-size-fits-all situation. There are small communities that for whom any drug coming in and in which possession is involved needs to be prosecuted in order to allow that community to exercise its ability to stem a tide or prevent it from coming. So it recognizes that there are a number of situations where prosecution of simple possession is still very appropriate. We've moved from 10,000 files down to 3,000 files. So we still do simple possession prosecutions in this country as a prosecution service, but we do it when one of those circumstances is involved.
Thank you, sir. And acknowledging now that cannabis and marijuana possession, those charges are largely a thing of a past. What type of drugs would typically what would be the top three where in cases where charges for possession are being laid?
Fentanyl, methamphetamine, benzodiazepines. Cocaine is always associated with those as well, unfortunately. Cocaine is being laced with benzos and fentanyls, and having the combination of all of those is a terrible, terrible combination. But those are typical drugs.
Do I have any time? Time is up. Your sign says, okay, that answers my question.
I listened very carefully to the outline of your own journey through the PPSC, having started at its inception, taking on a senior role, contributing to the drafting of national security legislation in what became ultimately the Anti-Terrorism Act, and overseeing prosecutions, including one in which I was involved in the Toronto 18. And I raised that case because it was a seminal case. It was a case that involved a conspiracy around a self-radicalized domestic terror cell, and it implicated a number of different agencies, not only the PPSC and conventional law enforcement, but equally intelligence agencies. And I raise this in the current climate because one of the important debates that's occurring right now is how we use intelligence and convert intelligence into admissible evidence for the purposes of prosecuting individuals who have been charged under national security provisions. And so, having had the benefit to see Bill C-70 and understanding that it is currently making its way through Parliament, I wonder if you can, in your own extensive experience, shed some light on how we can improve the protocols around taking intelligence and converting it into evidence for the purposes of prosecuting individuals who are charged under national security provisions.
Thank you. The issue of intelligence and evidence is one that's been at the forefront for a long time. It's a very complicated one, and as the National Security Intelligence Committee of Parliamentarians recognized in their recent report, it has its own requirements for study and consideration. I can speak to the operational cooperation that exists and the efforts that are made. And over the last number of years, significant efforts have been made by the RCMP and CSIS and other members of the intelligence community to do everything possible to ensure that materials that are relevant to a possible threat to the security of the country, to safety of individuals, to our well-being and our institutions, is shared in a timely fashion, and is shared in a way that's very clear, so that it's something that the police, when they receive it, they know what they can do with it and what they can't do with it. And that's a significant element, because oftentimes in the past there have been circumstances where the two institutions work so closely, but they have such different focuses and mandates that the question of when and what it can be used for require clarification, and that's come.
One of the questions that keeps coming to my mind regarding hate crimes is the definition of hate. There is a proposal in a draft bill. We'll be seeing what we do with it in the committee. But in a few words, could you give me the definition that appears to you to be the most appropriate of what constitutes hate? Or if you can't do so, perhaps you could indicate whether there's a way in which we could improve our understanding and our definition of hatred in the criminal code. Hate crimes are under provincial responsibility for the provincial prosecution services. In the context of the Terrorism Act, we focus on questions of ideology using hate. Often, this ideology seeks to identify an other, a person or a group or a belief involving people that the ideology wishes to exclude from Canadian society, and that it seeks to attack at the same time. But it depends on the ideology. Currently, Section 319 of the Criminal Code, which prohibits fomenting anti-Semitism or hate, includes exceptions. It says that reasonable defense would be if the accused of one of these crimes is based on a religious text. I'm summing up in my own words. Do you have an opinion about that matter? Is this good or not to have this kind of provision in the criminal code allowing one to commit hate crimes if one is basing oneself on a sincere religious belief? I cannot offer a point of view on a bill that's before Parliament, particularly in a context in which the other prosecution services must lead the prosecutions. Thank you.
Congratulate you on your nomination and apologize. I'm allergic to this room, so I have an interesting dust allergy in Ontario, which is fun. But I think, I heard a lot of what you were saying earlier in response to some of the members that have already asked questions. And the committee is currently concluding its study on the rise of anti-Semitism and Islamophobia in Canada. And we all know the outcomes have been incredibly painful. Can you please comment on the low levels of successful prosecutions for hate crimes and whether this is a problem with the laws that Canada currently has, or are there other causes that are impeding successful prosecutions?
Respectfully, I'm not able to comment on the prosecutions that are conducted by the provincial prosecution services, which are the ones that conduct them, except in the north where we conduct them, and we have not had hate crime prosecutions in the Northern Territories.
I'm going to follow up on a question that my colleague Mr. Moore asked about decriminalization of possession of small amounts of illicit drugs. And I want to focus particularly on what happened in my home province of British Columbia with the pilot project with the federal government giving an exemption to British Columbia under the Controlled Drugs and Substances Act. It's a 3-year pilot project. But a year into it, it was clear that it was a failed project, and it's been rolled back substantially now. Again, the province and the federal government working together. So I wonder if you could elaborate on that, because prior to that, I understand that there was de facto decriminalization in any event, not only in British Columbia but across the country, for possession of small amounts for personal use. So what big difference did the exemption order make? And now that it's been rolled back, what are prosecutions going to look like going forward?
Thank you for the question. There is a perception that there was a decriminalization, in fact, of a simple possession. But as I indicated, I think the statistics bear out differently. That in fact we continue to prosecute simple possessions across the country, as did Quebec and New Brunswick, but only in those circumstances where one of the other complicating factors were present, the things that affected public safety, and. One of in British Columbia in particular, however, there was very few of those prosecutions that went forward. There were few of those instances that were brought to us where there were those public safety elements. With the change in the exemption, I think the primary effect will be affecting what police can and can't do with respect to their interventions. Then their decisions as to whether or not that translates into a prosecution is another matter. But they will be in a position, I think, to be able to have interventions in a different way than they were while the exemption was in place. And in many ways, they are the organization that is on the front lines. They are the one with the biggest footprint with respect to dealing with the persons who are subject to these substance use disorders. But whether that translates into prosecutions, I don't know, because, again, there are many avenues to address the underlying problem. And we've had tremendous success with respect to many of them, including such things as drug treatment courts. So it will depend on the police and their decisions as to what they refer.
But it also depends on your office, doesn't it? You have said that you give clear directions to prosecutors about how prosecutions are to be undertaken or which cases even are to be prosecuted. So to what extent does the prosecution office in British Columbia rely on directions from your office?
I would like to think they rely entirely on them because no person and no prosecutor, no matter how well intentioned, is their own determinant. We're all persons who have a responsibility to others and report to others, and ultimately, as DPP, I would report to the Attorney General. But there is scope for local practice, and both within larger and smaller communities, and from province to province.
So I'd like to ask you. You said you report to the Attorney General. You had written recently about the Shawcross principle and the rule of law. Central to these principles, of course, is the independence of the prosecution service. Given that in Canada, the Minister of Justice and the Attorney General is one and the same person, how does that affect prosecutorial independence?
Them being in one and the same person, in my experience, has never affected prosecutorial independence. I've had the pleasure of dealing with a number of attorneys general since we were created, and I have never found that there has been an issue with respect to the manner in which they approach the attorney general function. They're scrupulous in the way they approach it. All of them have been.
My understanding is that in the United Kingdom, those two roles might be separated. I don't know if that's always the case or
They are separated there, but the McClellan report looked at that issue and concluded that what we had in Canada was something that was functioning well. And again, in my experience, every Attorney General has respected the independence of the prosecution service entirely and scrupulously.
Do I still have time for one quick question? You do. Okay, good. So you had mentioned the London family case.
I was giving you 6 minutes.
Thank you very
go
much.
Go ahead,
for
ask your question. And
okay,
then maybe
I'll keep it very quick then. The Asfeld family case, the person was charged and convicted of 4 cases of murder, but also terrorism acts. Although in the Quebec City mosque killing, the terrorism charges were not laid. And I wonder what the difference would be, and if you could give your sort of academic opinion on that.
The difference, in short, is that the difference is evidence. Each case has its own evidence. And in each case, you have to assess the evidence to determine whether, based on the admissible evidence, you can meet the beyond a reasonable doubt standard. And that's the difference between the two cases. That's the only difference between the two cases.
Thank you very much.
A question that Mr. Mendicino had brought up, and then Mr. Fortin brought up, which is how we're dealing with anti-Semitic hate in this country and other forms of hate, such as Islamophobia. And I want to refer you to recent statements by Adil Sharkawi, where Mr. Sharkawi in Montreal on October the 28th of last year made a speech in Arabic where he said, Allah take care of these Zionist aggressors, Allah take care of the enemies of the people of Gaza, Allah identify them all, then exterminate them, and don't spare any of them. And the Quebec Prosecution Service, the DPCP, determined that there wasn't sufficient evidence to reveal the commission of a criminal offense under, I presume, sections 318 and 319 of the Criminal Code. Mr. Dolhai, would your office have in any way been involved in offering advice on an issue like that, or will this be an issue in terms of the way that we prosecute 318 and 319 offenses that you would undertake would be part of the next discussions with the provinces when you have future rounds of meetings?
I can't comment, Mr. Housefeather, I can't comment on any particular case or any particular situation and what consultations were or weren't had, because those would also raise issues with respect to what was or wasn't referred to us by the police. But certainly, I expect that one of the things that will be front and center in our discussions at our next heads of prosecution meeting, if I were to be there co-chairing that, would be the question of how we cooperate and coordinate around issues as to how to deal with the hate crimes and how we ensure that there is no light left between the criminal code provisions and the terrorism provisions, as far as ensuring that there is that circumstances meriting prosecution are dealt with.
Thank you.